Good afternoon, this is Sean Golding with Golding & Golding, here to discuss a recent case that we've been getting a lot of questions on regarding a recent 11th Circuit FBAR reckless disregard case in the US versus Rum. So by way of brief background, when the US government wants to prove FBAR penalties and they want to prove willfulness, they don't necessarily have to prove intent. They have to show reckless disregard. But what really qualifies as reckless disregard, and can they really do that, is a common question. So in US versus Rum, FBAR lawsuit was filed regarding FBAR penalties. The US government claimed the taxpayer was willful, and of course the taxpayer disputed and said he was non-willful. Initially in the underlying case, the first agent had opined that the defendant was actually non-willful, and then that ended up, or the recommendation was non-willful, and then it went into willfulness. So here, the government's trying to prove reckless disregard. They're trying to show that essentially he should have known, right? In this particular scenario, they're trying to show a lower level of willfulness, not that there was any intent or actual knowledge, but rather there was not necessarily a direct intent as much as the guy should have known, based on what the IRS is saying. And the key factor, or the key important note to take away from this, is even if the government is only able to show reckless disregard, lower level of willfulness, they're still able to go after the defendant for the full amount of the penalties. So it's not like, well, they couldn't show you were intent or that you had knowledge, so they're going to hit you with less penalties. They still go after you for the same amount of willfulness. And in this case, similar to a recent Court of Federal Claims case, the court said, the government's met the burden of reckless disregard. How did they do that? Well, first, they said taxpayer provided inconsistent statements throughout his representation to the IRS. At one point, he said he had a tax preparer. Another point, he said he didn't. At one point, he said, he wasn't sure whether income had to be reported, yet he was reporting some of the income, but he wasn't reporting the full amount, and there was really no specific or good reason given as to why maybe 10% of the income is being reported. Another important fact is that it was around the 2006 to 2010 time period, and that's around the time where UBS and other Swiss banks had entered into deferred prosecution agreements. Taxpayer defendant had an account at UBS. Apparently, the defendant was very active, had met with the financial professionals several times, and so there was no kind of concern where, like in some situations, someone inherits a numbered account from a Swiss bank, they know nothing about it, they didn't set it up, they don't talk to the financial professional. Since it's a numbered account, they never get the information, and so they never thought twice about it. It wasn't their money, quote unquote, to begin with. If you think that you may become subject to FBAR penalties, you want to try to avoid it. There's various disclosure programs available. There's VDP if you're willful or can't certify under penalty of perjury that you're non-willful. There are the streamlined programs, streamlined domestic and offshore, delinquency and reasonable cause. We have lots of free information available on our main websites and our sub-websites. Main website's goldinglawyers.com. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.